welcome you to today's webinar brought to you by Alere Toxicology. Alere is a leading provider in drug and alcohol testing services to the workplace, criminal justice, consumer, and clinical markets. Alere offers state-of-the-art laboratory services at a number of locations across the country, including 3 SAMHSA-certified facilities. Alere is also a leading provider of point-of-collection testing products for urine and oral fluid specimens, as well as breath and saliva for alcohol screening. This presentation is entitled OSHA Compliance, Creating Clarity for Post-Accident Testing, and presented by Nina French of the Current Consulting Group. Nina is the managing partner for the Current Consulting Group with over 24 years of experience in employee screening. She specializes in product and business development, drug testing, marketing, and sales strategy, and in occupational health and wellness operations, as well as part of an overall screening organization. Has experience in managing drug-free workplace teams, including vendor management, medical review, client services, account management, and sales support. Her consulting emphasis is on helping employee screening providers streamline operations, launch products, increase revenue, and retain existing clients. Current Consulting Group is a tenured team of experts in the drug screening industry who together offer a comprehensive lineup of expert consulting services. It will now be our pleasure to hear from Nina French.
Good evening, everyone, and welcome to today's presentation. Our presentation today is in 3 parts. We're going to cover OSHA's record-keeping and rulemaking rationale, and then the impact on post-accident drug testing, and then finally we're going to end with what employers can do. There's a lot of content, which is a bit of a surprise because each time we've covered this material, I sort of start with how little there really is and then end with how much there is to talk about. And I think you're going to find that as we go through these slides today. What we like to do is to clear up the confusion that has really stirred up with employers since really about August of this year, but really has existed now for several years since the rulemaking has come out. And so we're going to start with that. And what I'd like to do is to go through the slides today and to make sure that you walk away from here understanding the story of what occurred, understanding the history of what happened, and then understanding what you need to do and what you can do to make sure that you as an employer are covered and you're in compliance. And that's what we hope to walk away from today's meeting with. So let's start with OSHA did. And we are not going to cover the details. We are not OSHA expert, drug testing experts. So what we're going to cover today specifically is about OSHA relates to drug testing. But really, in a nutshell, it started with this rulemaking. So in drug testing, and like Jessica mentioned, I've been doing drug testing for 25 years of my life. In drug testing, when we talk about regulations, we talk about, drug testing or non-regulated drug testing. We don't talk about FAR 29 CFR 1904. We don't talk about OSHA regulations. But so when the OSHA regulations came out, what it talked about was a call for employers to electronically submit injury and illness data that they were already recording. It did not hit our radar. Had to do with drug testing. And ultimately what OSHA was saying that they believed the new rule would nudge employers to prevent injuries because they were really going to make public that it's safe workplaces. They were going to show their hand. They were going to show investors. They were going to show the public. They were going to show OSHA what their injury and illness data looked like. So that the outcome would be that more attention would bring about life saving and would bring about money saving. And that then, another bit of that would be that it would be improved accuracy of the data. No longer they just be having work, these injury and illness data on paper forms, but there would be improved accuracy of data, and that the workers would not fear retaliation for reporting their injuries and illnesses. So again, this didn't really hit the radar in terms of drug testing when it very first happened. So further explanation, right, outside of that nutshell, what it really said was that certain employers would electronically submit this injury and illness data on-site OSHA injury and illness forms. Then the analysis of the data would enable OSHA to use the enforcement and compliance, and they could use their resources more efficiently. And remember a couple years ago, so you're thinking now 2013, 14, 15, when the buzzword was big data, big data, big data. Not that it's not still important, but it was very much something that we were all hearing about in the news. So the idea was that OSHA would really start to get that data, and they would be able to use it more efficiently, and they would be able to take it and use it so that their resources could better and more effectively be used, which is great, right, because that's all of our tax dollars. And some of that data would be posted on OSHA's website, and then OSHA believed that by posting it as a worker or as a job seeker or as customer or as just a general public or a researcher or, again, back to being an investor, you would be able to see that information and use it to determine if it was, a safe workplace. And that, to some degree, it was the idea of peer pressure or public pressure to workplaces to maintain a safe work environment. And the amount of data submitted would vary by the size of the company and the type of the industry, but that they were going to get a much more comprehensive set of data by getting it electronically. So it all made sense. And real follow-up information was that this OSHA poster was going to be put in works, and this was standard. This didn't change. This poster's been around, and you can go on www.osha.gov, and there it was, and it was going to be posted, and it was going to tell workers that they were not going to be discriminated against and that they should injury occurs. And so, again, this really flew under the radar of the drug testing industry when it happened. And so, linked to drug testing. When did this start to come onto the radar of drug testing? Well, this is where it started to come onto the radar of drug testing. The point was, it is critical that employers do not discriminate or retaliate against an employee who reports an injury or illness. And that seemed completely normal. It's like a statement. And new regulation requires a reasonable basis for employers to require a drug test. Work-related injury or illness is reported. This is when it started to snowball. And so this is where we're going to move into part 2. And we're going to cover some things over and over and over again so that everybody on the phone really gets an understanding of, again, sort of how things got interpreted, how things got misinterpreted. Because the misinterpretation was not because you as an employer misread. it wasn't because you as an employer heard it wrong or got confused. The misinterpretation was legitimate in many cases, and you're going to see as we go through how these regulations came out and the history, how this happened, and how we're, now several years into this, where our understanding is and why it's where it's at and how things changed. And I think with the history, you can walk away with feeling much more that you're on firmer footing and understanding where you need to be today and moving forward. So motivation is really the key. It's the critical cornerstone of the new rulemaking. Again, shell is that this is about electronic record keeping of injuries. Drug testing and the impact to drug testing was not the primary part of rulemaking. But for the first time, OSHA will be determining what motivated the employer to issue the discipline. So enforcing a safety rule, following an injury reporting system, are they in compliance with a drug-free workplace? And we're going to talk about what that means. Those things are okay, but it is retaliatory. If the employer is being retaliatory, it is not. And let's talk about how did it tie into the link to drug testing. So I'm going to go back to history, and we're going to go back to the sponsor of this webinar, Alir. I'm having a conversation with someone from Alir back in August of 2014, and with DASHA, which is the Drug and Alcohol Testing Industry Association. And this is the first time it came to CG's attention when in August issued a supplemental notice of rulemaking. It was related to its November 7th, 2013. Again, we now, December 9th of 2016, we're talking about the notice of proposed rulemaking to amend OSHA's in illness reporting requirements from November 7th of 2013. So we are 3 years out and do a webinar now. So you can understand how history is playing a role in this. So in August of 2014, they issued a supplemental notice, their proposed rulemaking from November of 2013. And that was when they originally said, hey, this is a notice of proposed rulemaking. We're amending our requirements to add new electronic reporting obligations. That's when it flew under the radar. We didn't care. It wasn't our issue in the drug testing world. We didn't care. The supplemental notice said OSHA considers any retaliation against an employee for reporting a work-related illness or injury a violation. And from a drug testing perspective, everybody said, all right, we don't care. Okay, we're good. That's all good. That sounds like good business practice. Details. And he said we are going to add 3 new provisions to 29 CFR 1904-35. And the provisions will require employees to inform employees of their right toward injuries and illnesses from discrimination or retaliation. That goes back to that poster. And good. Implement injury and illness reporting requirements, well, and not unduly burdensome. Again, that makes sense, right? So you want to make sure that people can report it. It's not going to be super difficult. It's not going to be, within 15 minutes of the injury or accident happening. Those things all were very sensible. And then prohibit disciplining employees for reporting injuries and illnesses, right? So that means, too, you're not going to reprimand or discipline an employee because they reported an illness. You're not going to get them in trouble. And then that, though, this is where they started to detail it, because then they said in this supplement, under the new rules, the following types of employer activities are expressly prohibited. First one said mandatory drug testing mandatory drug testing every time an employee reports an injury. There is a reason to suspect drug use, and that is when, ladies and gentlemen, all of the flags went up. And when the confusion started, because everybody started to say, wait a second, does that mean if I'm covered under OSHA, I'm no longer allowed drug tests my employees post-accident drug testing? Because that's what it says. I'm sure that's what it says. Now, I'm not going to go into it, but during that same exact time, there were additional, I think, 6 points. We don't have time to go over them. But there was a 60-day comment period after the August 14, 2014 supplemental ruling. So they expected these new rules to go into effect January 1st, 2015. Obviously, they didn't, but they expected them to go into effect March 2015. They didn't, but this is when the flag went up, and this is when the confusion started from that single number one item. People started to say, okay, I don't think I can do drug testing anymore for post-accident. The key points were not to discriminate or retaliate against the employee who reports the injury. And really, what it said was that you cannot have a mandatory drug test. The point said you can't drug test. So this is where confusion started. At no point said that you would be fined. It at no point said that you would be out of compliance. It at no point said that you would be determined to be out of compliance or that you would be, scrutinized by OSHA, that if you did post-accident drug testing. And yet, employers started to say, well, maybe I should just drop it all together. It all together leads to different issues altogether, right? On a totally different front, as an employer, could you be deemed to not be taking reasonable accommodations to have a safe workplace out of OSHA? A different issue, right? So it just simply said that mandatory drug testing or a blanket policy for post-accident drug testing would be considered discriminatory and could lead to a fine. Actually now, after the original intent was a March 30th, 2015 implementation, it has officially now gone into effect December 1st, 2016. So it is official. Enforcement has begun. Now, it's been delayed for several different reasons. 2 times it was delayed now because on August 31st, it was originally to go into effect. It got delayed to November 1st, and then it got delayed to December 1st. There is ongoing litigation. It is upheld in a recent judgment, and I'm going to explain a little bit. I'm not going to go into too much detail. If you are interested, you certainly can go into detail, but the National Association of Manufacturers and Associated Builders and Contractors have and a lot of other associations and employers have a case in federal court in Texas, and they're seeking to block parts of this new OSHA rule. The lawsuit says that parts of the rule dealing with discrimination and retaliation are really just exceeding the agency's authority, and they are interfering with the state workers' compensation laws. There were guess that it was actually going to even push out further the December 1st implementation date, but Judge Lindsay, who's overseeing this case, denied that, and so it did go into effect on December 1st. And you can read all about that. It's in the news. It was well published and many articles out there. But so this is officially in effect. It does not mean that Judge Lindsay dismissed the case. It just meant that he went ahead with putting OSHA's ability to enforce in place as of December 1st. I mean that lawsuit's not live because it is. So if you want more information on it, feel free to look at it. But let's start to dissect now a little more about OSHA's rationale when it comes to the drug testing and why they are talking about the blanket rule. Because I think understanding it will help you feel comfortable with your policy as you put it into place, and understanding that as you put it into process in your workplace, when you understand what the rationale was and how you apply it into your workplace, understanding it to this degree rather than just sort of reading the text and reciting it, you're going to feel comfortable that your policies and your procedures make sense and that you are complying with what OSHA wanted and why they wanted it. So they believe that the evidence in the rulemaking record shows that blanket post-injury drug testing policies deter proper reporting. This is direct language from OSHA. The final rule does not prohibit employers from using drug testing or the threat of drug testing. Now, I think it's funny that they use the word the threat of drug testing, right? I think it'd be better to say or the policy of drug testing, or the threat of drug testing as a form of adverse action against employees who report injuries or accidents, injuries or illnesses. So what we're saying is to strike the appropriate balance here. Drug testing policies should limit post-accident testing to situations in which employees' drugs is likely to have contributed. In the very first ruling in this year in May, when they came out with it, in the preamble, the description was about a bee sting. And they said, so if you got a bee sting, you would not drug test the employee. And a lot of people said, well, maybe I would, right? Maybe I would, because what if the person was poking a beehive? Business being out in the yard and was poking the beehive. Maybe I would. So people thought, well, you know what, that actually might have been a really good description. And so there is a level of discretion, and we're going to talk about ways that you can continue to have a level of discretion in your workplace. And that is the thing that I think is most uncomfortable to some degree to employers, that there is not necessarily a black and white line in some cases. And if you are in safety or in HR, we're going to talk about the role that documentation and further, but like a decision tree and policy plays and how important that is in implementing the OSHA rules going forward in your workplace. But this is really what this is about. You don't want to have a blanket policy, but your policy and your ability to perform post-accident drug testing is still extraordinarily enforceable. And I would hazard a guess that outside of having sort of a mandatory policy in all cases and some very black and white cases, and we'll talk about what those are, you're going to see a very slim reduction in terms of reportable incidents that result in a drug test across the board. So the original source of confusion, right, where people panicked and said, oh my gosh, I can't do drug testing. The secondary publication that came out in May of 2016 caused confusion on several fronts. So first there was that mistaken belief that you were being discouraged from continuing post-accident drug testing. And so we got inundated with phone calls at CCG. I know that Aleer was inundated with phone calls. And across the industry, people were asking, are we allowed to do post-accident drug testing. The second thing that the preamble, so in OSHA's, in May of this year, it was actually about 250 pages, and the only time drug testing was discussed at all was in the preamble, and there were 9 pages where it was discussed. So it's actually not part of the rulemaking where you can cite it, 1904B, there's none of that. It was in the preamble. And where it talked about drug testing, they made this statement, that employers were required to use a drug test that showed impairment. And this went up. And we'll talk about why. Why is because there is no such drug test technology today. So next month, Lear is hosting a legislative update, and all of you, I'm sure, read daily, weekly, monthly about legalized marijuana, the cost that legalized marijuana is going to bring to taxpayers, the cost of legalized marijuana to employers, right, to the country. We're all going to get hit hard with that. Impairment is a big piece of that issue. Impairment is a challenge to all of you as employers. There's no current technology that shows impairment. You can't know exactly when this occurred. And so talk about how you can use technology that's available at laboratories today to show recent use. When OSHA said in their memo, impairment, it caused confusion because there is no technology that can exactly show impairment occur, that there was impairment in drug use or in the drug test right at that moment. So both were incorrect, and OSHA now came back in October of 2016 and reinforced and clarified that that statement was incorrect. They didn't really come out and say that's precisely, but clarified that employers could have some additional clarity in what they meant, and we'll talk about what that meant. So employers can and still use post-accident drug screening. They have a reasonable basis, right? A reasonable basis. Rule doesn't apply to anything outside of injury reporting. OSHA will not issue citation for drug testing conducted under state workers' compensation law or any other state or federal regulation. Those 2 last bullets are key points. We're going to hit them 5 or more times in the next couple slides, right? So you are complying with a mandatory state does not apply. If you are complying with a federal regulation like the DOT, OSHA doesn't apply. If you are complying with a voluntary workers' compensation premium discount law, voluntary compensation denial law, a free workplace policy under your state law, an industry law in your state, OSHA does not apply. One of those tests in the bullets we had, remember the circles, thumbs up, thumbs down? OSHA will not issue citations for drug testing conducted under a state or a federal regulation. So look at your policy, review your policy. If your policy is having post-accident drug screening under one of those, then you are in compliance. And differentiators, okay? Important differentiators. It does not prohibit employers from drug testing employees who report work-related injuries if you have an objectively reasonable basis for testing. So if you believe impairment could have caused the drug test, could have caused the injury or illness, under OSHA, it is okay to test that person. We're going to have some other examples. But the person was driving a forklift and according to me, I was injured, but the driver was not injured. Me, because I was injured. But yes, the forklift driver. He. But discriminatory under the OSHA rules, we will be tested. Because impairment could have caused it on both of our parts. Me, because I didn't maybe move out of the way, but my injury was there. And the driver, because he or she crashed into me. So test us both. You want to have policies and decision trees that help guide you, say, objectively reasonable that impairment or use caused the injury. Keep in mind that this is just all about the injury and accidents. So pre-employment, promotion, random, all of those other reasons for tests don't apply. Again, we have seen sort of like a little bit of a widespread panic to some degree, which was took me by surprise. We're going to discontinue testing. It didn't make much sense to me. But not applies to anything outside of OSHA and outside of the post-accident or post-injury testing. And none of it applies if we are under a state or federal law. All things are protected. In all cases, OSHA has to establish 3 elements of retaliation to prove a violation. And I'm not going to lie to you. The violations and the ability to fine, it's fairly significant. It's over $10,000 for a fine. And they've changed it a little bit. You can look that up. But they're fairly significant fines. I mean, I guess but depending on your size, violations would change. And I guess depending on your size as an employer, significant varies as well. I'm a small employer, so significant really different than a very, very, very large employer. But they're sizable. But in each case, OSHA is going to have to establish 3 elements of retaliation. So a protected report of an injury or illness, adverse action, and causation. So again, that very lawyerly, no offense to anybody who's on the call who's a lawyer, we're going to talk about sort of what that means. A central inquiry for an evaluation by OSHA will be whether the employer had a reasonable basis. Keeping that over and over and over again, reasonable basis for believing that drug use by the reporting employee could have contributed to the injury or illness. Times like this where I wish I was, my training, originally my training as a teacher came into play because I would ask the question, if I came in and I reported that I had a repetitive motion injury from work line in factory, would you test me? The basis doesn't exist, right? The chance that my repetitive motion injury that I reported is a result of drug use is slim. If looking at a reasonable basis test, that's not going to cut mustard. So you need to have those reasonable basis tests as part of your process. So evaluation and documentation is key. Whether the employer had a reasonable basis for concluding that the drug use could have contributed to the injury or illness, therefore the result of the drug test could give you insight into why the injury or illness occurred, right? Were other employees involved in the incident that caused the injury or illness were also tested. So back to the forklift, right? Employer only tested the employee who reported the injury or illness. So again, I got hit, reported the injury because I got hit by the forklift driver. So injury or illness because I had to go because my foot got run over. But it makes sense when you are determining the reasonable basis and determining who should have the drug test that we would both be tested, because it makes sense that the insight for the drug test and drug use have contributed to the injury or illness. It makes sense that we would both be tested in that case. And so that is one of the key areas that you want to